This is pretty obvious. If you look at the slide, what is copyrightable subject matter in China? What is interesting is what I underlined: drawings or engineering designs and product designs, which overlaps a little bit with patent law. So you can have sort of double protection. It might make sense to register a drawing, a blueprint of a product, because especially at an early stage, when you are only preparing to file a patent application, or you are still working on the product, because there is no review if you're registering copyright, and it gives you a longer protection. So you have 50 years after the death of the author, or the longest surviving co-author. You have basically the same, or materially the same regulations in these selected countries from Southeastern Asia. Again, the same thing. You have automatic protection, so the creation of a copyrightable work is enough to get the protection. But from practical matters, you want to register, and for example, in Poland, there is no place, there is actually no entity with which you could register a copyright. I mean, if I apply to the patent office with copyright, they will just write me a polite letter saying that, yeah, I must have been mistaken because you don't register copyrights. In all those countries, you have actually within the copyright regime, within the copyright acts, you have a procedure for registering a copyright. It's clearly stated that it's not obligatory, so you will have automatic protection without registration, and you will have a government authority responsible for handling the registrations. Sometimes it's fairly simple. What you need to do is you need a copy of the work, which might be a book, a sketch, a recording, and you need a declaration of your authorship. And it's not really, unless it's challenged by someone, it's not really reviewed. So it's sort of a very simple regime. Copyright is not, though, I mean, even if it sounds nice, it's not very practical. I mean, unless you work in a publishing, media, filmmaking industry, it's not really that practical for you. As a, business entity which enters Asia, and you want to, offer your product or, manufacture anything there, I would say then that you can just keep copyright protection, unless you really have something. But then usually, for example, publishing or media, television, movie distribution, those are industries that are usually regulated. At least in China, you won't be able to do it on your own. You will be, as a foreign investor, you will be prohibited from investing in the media industry. You cannot be internet provider, you cannot publish a newspaper, you cannot be owner of TV station. So with China is sort of complicated, which probably extends the scope of our discussion today. But when you are thinking about conducting business there, you should check if you're actually allowed to conduct business in this particular industry, in this particular field. So sometimes you need to have a Chinese partner. Sometimes you need to have a Chinese partner who is a majority owner of the company, and sometimes you're simply prohibited from conducting a business in a particular field or acquiring shares in a company. And the media industry is one of the examples. So another digression, which I'm apologizing for, but copyright is not that important for you. Trademarks, they are very important for you. As I mentioned before the break, giving an example of unfortunate turn of events for one of my clients, a company I was working with. You need to be very firm on protecting your trademark if you want to offer. Even if you're not planning to do it now, if in some perspective you want to offer your product or services on Chinese market, you need to be very firm on getting your trademark registered. One of the reasons is that China and all the South Asian countries we are discussing about, they are so-called first to file jurisdictions. So you will have priority if you are the entity which applies for the protection first, and it applies both to trademarks and patents. With patents, you have better chances in disputing with a competitor, and you can also you have some margin of changing and adjusting your patent application in such a way that it's not directly conflicting with something else. You might also have a better chance to prove that some technology was stolen from you, that it was the industrial espionage taking place. With trademarks, it's pretty simple. What you file is just the design of your logo and the description of the service or product that you are offering. I mean, to which the trademark will be used for. What is interesting and what is worth to note that in China, trademarks are usually, they need to be localized, and that is due to the language barrier or linguistic issue. What you want is that your trademark is recognizable and it has a nice or positive connotations for Chinese customers. Usually, just following, the original name in the original language doesn't work that great. I mean, it's not really. It doesn't easily become a part of everyday language and the understanding of by the Chinese customers. You have a number. I mean, here you have 3 examples of localizations, and they all have been pretty successful. What you do is you translate your name, and you can do it in 3 different ways. One is just you focus on the idea. You focus on the primary visual rather than literary part of the trademark. And Apple here is a very good example, because what this is called in China, I mean, you use very distinctive logo, visual design, and you call it just Apple, but in Chinese, which is Pingguo, but it doesn't sound like Apple, right? It works really nicely with something that is simple and which corresponds with the marketing, with the visualization of the product and the marketing focus on a simple communication. A little bit more tricky is when you go with something that doesn't really have a meaning in the original language. Like you can't really translate Coke. I mean, it's just a brand name, right? It's not really a word of a distinct meaning in English or in another European language. So what you need to do is you either go for similar sounding expression, and that can be very, very tricky, because involuntarily you can get into something that is ridiculous, which is insulting, which is offensive in Chinese. I think Peugeot, the car manufacturer, they had a quite unfortunate start in China back in the 80s, where they translated Peugeot in something, I don't really know the details, you can probably Google that. Their Chinese transliteration of their name was referring to prostitution, which wasn't really, which it was funny or slash insulting. So not a really good idea. What you need to do is you need to have a really good copywriter, someone who is a native speaker of Chinese and also has a very nice imagination. The thing with Chinese is that the characters they all have meaning. So it's not a phonetic language in the sense of it's not a phonetic script. It has they are all pronounced in a certain way, but they have a meaning, and you need to be very careful about this meaning. So you either go for something that's, preferably for something like Coke, that it sounds very similar, and it also has a nice meaning, like a meaning which preferably goes with your how you want to be perceived on the market, or you go for something like Sheraton, which means Xilai Deng. This Xilai, it's something about arriving in a comfortable place, which doesn't sound like Sheraton, but the meaning is kind of comforting and nice. With Coca-Cola, it's really great. It's one of the best trademarks in China, best localization of trademark in China, because it both sounds similar to the original one, to the original name. It even kind of like preserve the original intonation, but also the meaning refers to basically good taste in your mouth, like a great taste in your mouth, or happiness in your mouth, which is a great line for an advertisement. If we go back for a moment to China, what is part of this first to file jurisdiction is that you don't have a recognition for well-known trademarks. So even if some trademark is very popular, it's known worldwide, you won't get any preferences in China. Any preferences in proving that this is actually a trademark if you had someone else registering it. Most of the countries would give you a protection for well-known trademark, even without registering, or when you actually apply for registration, they will take that into account. There was a dispute concerning Apple computers in China, which they lost, and they needed to acquire the trademark, even though at that time, it was quite recently, even though at that time they were a well-known trademark, both internationally and in China. So you might have a sense that this trademark protection is quite unfair. It is, but on the other hand, if you know what to expect, so you need to be very careful when entering Chinese market to at least to spend a minute and think, do I need trademark protection? Am I going to offer something where the identity on the market works to my benefit, or like significantly works to my benefit? If I'm always going to be a subcontractor providing software development services for, let's say, telecom industry, and I don't really show my identity, I don't really show my logo to the public. I only work for limited, list of customers, and they know me. They don't care, whether I have a trademark or not. They're just interested in the quality of my work. Then probably not. But try to, figure out what might be the likely scenario in some longer time, and you will have, trademark protection is a must if you want to offer your products in China. It might also be quite important if you're exporting from China. So if you're producing in China and you're exporting, because China which is quite unusual, they control not only imports but also exports. And one of the reasons, one of the grounds on which the export can be blocked is infringement of copyright, or infringement of IPR. And that will be usually trademarks, because trademarks are kind of like easy to spot. It requires, we will talk about it a little bit later when I will tell you about enforcement of IPR, but even if it doesn't strike you that you might need the trademark, please give it some thought. If you want to produce, that was another case. It's sort of, there wasn't a case, there wasn't a dispute or anything, but it just crossed my mind now that I was working with again, Polish producer of cutlery, and they were outsourcing making blades, I think, and some parts of the cutlery to China, and then they were assembling this product in Thailand and selling that in the Southeast Asian market. And the thing is that they didn't want to have trademark protection in China, and they were telling me it doesn't make sense, we're not going to sell in China, they're not interested in our cutlery, it's not really no market for us. We will be selling primarily in Thailand, and we will have our final assembly in Thailand because for some reason it made more sense with this product, with transportation costs or whatever. And I was like pushing them very hard and telling, okay, it's not that much money just to have your trademark also in China. If you're unlucky and you have your competitor, it's just opening yourself to a risk of a competitor who might actually block your business, who may disrupt your business model. And they were asking me, how come? We are just going to produce the blades, and on those blades there will be, our nice logo engraved. But we are not selling that in China. We're not planning to do that. We don't think that there will be anyone else following us, that there might be any counterfeited products, because there is no market basically for that. And I was telling them, okay, but if you are unlucky, then you might be blocked to actually export your product. It's just from China to another country. And what I'm trying to say is that you should give it a serious thought and look at your business model from different angles and see what might come in the future. all those countries, Thailand, Malaysia, Indonesia, and Vietnam, they do give you a protection of well-known trademarks, even though most of them are first to file jurisdictions. You will have, but this is kind of fancy. In some jurisdictions, like in Europe, you can register a sound, or I'm happy to send you the presentation if you want. It's, yeah, it will be easier to read and to whatever, use it in any way you wish. You just need to get in touch with the organizer, so he can send it, whatever. We'll work it out. I sort of lost track of my thought. Visual. Basically, the Asian jurisdictions are not that sophisticated. Sounds or scents are not considered to be trademarks, or you cannot register them as trademarks, and you won't get protection for a sound, a jingle, or something like that you have registered somewhere else. Usually, it's a simple and fairly cheap process to register a trademark, both in China and in Southeast Asia. You should be done with less than €1,000 in all those jurisdictions, including translating, including paying for your patent attorney. The fees are very low. I mean, very low. If I remember correctly, the fee for registration in China is something like 130, 40 euro, just the fee that you pay for the trademark office. Unless you get into a dispute, a court dispute, this is a very straightforward process. Yeah. But you will need assistance of Chinese lawyers, a Chinese lawyer. But there are so many of them and so many of good intellectual property lawyers in China that you won't have a problem with finding someone. And of course, you can do it all, from Europe. Just sending the power of attorney and actually consulting with what you want to register and how you want your trademark to look like. If you need to localize it, but localization, maybe it's not really necessary, every time. If you're not planning to target consumers, then maybe not. If you want to localize, the costs can be really high. It just depends on how, what will be the bill from your, marketing, advertising agency. Inventions. As I mentioned before, registration is required. There is China specifics. Inventions, registering a patent is kind of like a long and scary process. It's because of the obligatory review of a patent application, and that review requires a lot of interaction with the patent office and a lot of translation and going back and forth with additional questions. You, especially if you rely, if your patent application relies a lot on description, that can be quite tricky. You have, average time for registering a patent in China is something between 3 to 5 years, which is quite long. So you will get protection, of course, from the moment you initiate the proceedings. You file the application, but this is kind of tricky. What is a popular bypass of that is going for utility models. Utility models are are basically considered to be petty patents or smaller patents or less complicated patents, you won't have the obligatory review of the patent application because you don't have to prove the novelty. What you need to do is the inventive step, and you need to prove that there is industrial application, as opposed to invention patents when you need to prove the novelty, which means that you need to describe the prior art, and there will be and this is the core of the review. What is the prior art, and whether what you're proposing is new, is novel, is a step forward. So most of the, utility models, they give you a reasonable protection, and you get this protection pretty fast and pretty cheap. You have a shorter protection though, because it's only 10 years, as vis-a-vis 20 years for invention patents. If you look at the timeline, trademarks, they can be, you can renew the protection of trademark. So it's always yours, as long as you want, to keep this trademark and to pay for another 10 years. Then you can do that. You can renew. With patents, you don't really renew them. What you can do is you develop your technology, and you apply for another patent based on the as an improvement of this one. What is kind of tricky in the context of Asian countries, in particular China, taking into consideration their not very IPR friendly policies or the practice, is that you disclose quite a lot. And again, utility model can be a better option for you because you disclose less. The file that would be open to the public will not include detailed analysis of the prior art and novelty, and then there is not really, usually, because the patent office, they can review the application for the utility model as well. So there might be some correspondence and some further digging for evidence. But as a rule of thumb, when applying for the utility model patent, you disclose less, and you get the protection. You get the protection faster. I always think that, as opposed to the trademarks, you need to be very careful whether you really want to engage in patent protection in China, because of the length of the process, potential costs, and also full disclosure to the public. So you will actually be showing what you have to your potential competitors. You can flip this argument around and say, okay, if I have a patent application, if I have a patent anywhere, if I patented anything in the US, anyone can take a look into the application. But still, it will require some sophistication. It won't be in Chinese, it will be in English. It might be a stretch, but of course, you do have so-called patent trolls in China, and they are monitoring. Those are companies which are not really involved in a significant industrial activities. They just monitor patent applications around the world, and then they analyze that whether it can be used to get some patents valid in China, and then sort of block the others, including the original inventors, from using this, from seeking protection in China. Unless you really you're quite sure that you want to engage in manufacturing or working with your customers. I mean, providing technology to your customers in China, technology that is patentable, then I don't really see much benefit for you in getting a patent protection. In the Chinese context, sometimes trade secrets and protection and relying on the contractual obligations might be quite effective. Again, if you're not providing, if you're not just hitting the market with a product that can be easily reverse engineered. So as long as you're not really serious about entering Chinese market, if it's something like fully enter Chinese market and offer your product, probably, I mean, it might be a good idea, but it doesn't have to be a good idea, as opposed to trademarks. It needs some thorough analysis. What you can, if you're active on other markets, or if your primary markets are elsewhere, you can also rely on the import controls. So you can block importing Chinese products which infringe your patents, even though you don't have patent protection back in China, but you do have patent protection in Europe. You can block such products from entering EU market. First of all, jurisdiction. That's something that we covered. Oops, I think it doesn't. I should scroll down, yeah? Maybe we could just
remove the mouse on the laptop.
Uh-huh. So it's here, yeah? So it's this laptop?
Yes.
Oh, that's interesting. It's like frozen.
Yeah, sorry, no, it should be okay.
Yeah, it should be fine. Mm-hmm. Yeah. Sorry for the interruption. Again, the same, and this these types of patents, they come from the WTO framework. I mean, the distinguishing patents for inventions or inventive patents, the industrial designs, and utility models or utility patents. This is something that you will find in any legal system around the world, and this is kind of like uniform. You will have different names for that, but usually there will be the same context. Again, you will have the longest protection, up to 20 years, for the inventions, and the inventions, they require not only the industrial application and the novelty, but also inventive step, which is again prior art. Are we really making this not only original, not only new, but also significantly different from the prior art? So this inventive step would be, if you look at the understanding of the technology by specialist in this area, and whether what you're proposing would be an obvious outcome of the of the known technology or the known science in this field. If it's not obvious, then you are able to demonstrate that there is inventive component, inventive step. Again, utility solutions, the inventive step is not required. So you need to show that this is actually that you're actually able to apply that solution in the industry. So this is something practical. I mean, you cannot patent something that is that cannot be translated into an industrial process or an actual product, and that it's novel. So this solution is not being used on the market already. Industrial design. This is it. It is more related to the market visibility, to how you present yourself and how you present your product. There is a very short protection in Vietnam, only 5 years for that. It may overlap this is the strongest what you can get for industrial design, but it may overlap with trademark or with copyright in terms of the visualization of the product, which is also available under Vietnamese law. Again, first of all, jurisdiction. Vietnam is not that popular as China in terms of both patent applications and patent disputes. I think I mentioned that at the beginning, that China has quite a steady inflow of patent applications from the foreign companies, and a really increasing number of applications from Chinese industry, from Chinese companies. So this so there was a tremendous shift in thinking about patents as as a technology which is brought to China and needs protection, into using patents as a tool for competing among Chinese companies. Also, if you look at the priorities set out by the government, research and development is one of the heaviest financed. I mean, of course, different areas. If you think about research and development in general, especially green energy, telecommunications are heavily financed by the government. But just to realize what is going on there, it's worth to know that since 2004-2005, China spends more money. There are more funding available in China for research and development than the whole European Union. So the only country which spends more on research and development than China is the US. So they are pretty serious about this, progress in the technology and the science, and increasing or improving IPR protection is just the next step. So I think it will be, better and better in the terms of how the enforcement works, and how smooth the process of registering a patent and resolving a patent dispute goes. You will have more and more knowledgeable patent examiners and the judges in the courts dealing with the IPR issues. But what you need to remember, it will be always China-oriented. So I don't think that it will be in any way easier for the foreigners, for the foreign companies to take part, to benefit from the IPR system in China. It will be more and more accessible to Chinese companies. So, the language problem, the requirements to translate everything, etc., that's going to stay. You will just have it more and more popular. But Vietnam is not there yet. Applying for patents, maybe it's not such a big market yet. Maybe it's It's, I mean, the internal market is not that attractive in terms of, you know, counterfeited, I mean, fighting counterfeited products, etc. You don't have this this trend of increasing patent applications in the recent years. Basically same layout of what you can get protected in Thailand, just different names for those. You can get up to 10 years of utility model, and utility model in this context is industrial design, basically. What is borrowed from the US law is patentability of software. You need to prove, though, that, I mean, you cannot get patent protection for an algorithm. It needs to be a software which actually can be a part of hardware that can be working on a hardware. So you can't really skip the stage where you have a code, and this code needs to be treated as an input for a hardware process. But once when this condition is met, then what you actually get is the structure of the software is protected, not the expression, as in case of copyright law, where you protect the how the software. I mean, you protect it a little bit like a literary work. So what is written in the code, and when you compare your software and the software that you think is infringing your rights, you will look at how much code is taken from mine software. You might, in some more sophisticated jurisdictions, also look from so-called non-literal they are not called parts, non-literal aspects, and you can compare it to a structure of a novel, like structure of a plot of a story, and you can say, on a very general level, that this is a story about Irish family in the US in 1950s, talking about relations between generations in the same family and then the different experiences. That would be very general summarization of what is it about. You can do the same thing with the software. You just tell what is it for, what functionalities, and in very, very general terms it has. The other extreme is literally the novel, like word after word. You cannot copy that, but you can copy the general idea. Same thing with software. You cannot copy the code, but you can naturally offer another solution for the same problem. So you can offer the same software which addresses the same need. What is really, nobody will just copy the whole source code. What you really do is you look how the software works, and you copy or you might copy the functionalities, the algorithms, and patent protection is quite good in prohibiting from doing that. So you can look at the software as an abstract idea or a machine or a function and say, okay, how it works is actually protected. With the copyright protection, you don't get that far. So you can protect significant portions of the code, and you can protect also these non-literal aspects, but they need to be pretty close to the actual code. So you can get protection for the way how you solve an issue while coding, but not the algorithm. And thus usually if you are, I mean, it's a two-edged sword, because if you are a software developer, you're of course happy if you have pretty strong protection. On the other hand, strong protection of software, especially patent protection of software, it kind of at the same time limits your way of how you can work out problems when you are a software developer. So, and basically it's pretty rare to have patent protection for the software. And Thailand and I think also Japan are the only countries in Asia where you can actually exercise, when you can have a patent protection for software. Usually around the world it's the copyright. In China it's twofold. It's the Copyright Act, and they also have I don't remember the name, and it's pretty recent. So it was passed like 2002, I think, so 12 years ago, a special Software Protection Act. But they don't add anything new. They basically, they don't add anything new on top of the copyright protection. And you can actually, and it makes sense, you can register, you can have a registration of your copyright to the software in China. So you need to provide a copy of the thing. Indonesia, again, the same matrix. You have standard patents, so-called simple patents, and industrial designs. There's nothing pretty specific about Indonesia. The process is quite straightforward. The language is easy, so it's not that costly or complicated to have your documentation done in Indonesian, comparing to China. The patent office is quite efficient. I think that the average time the procedure takes, it's less than 2 years. Not very popular jurisdiction for patent protection. Again, as long as you're not engaged in offering your product there, you might not be interested in getting patent protection. I think in Malaysia, as far as I remember, they don't have the industrial designs regulated here or protected under their patent regimes. So they have only this twofold distinction into innovations patents and utility innovations. Utility innovations are not really. So distinguishing is not really based on the novelty issue, but you need to refer to an existing product or process. So this is sort of like dependent on patentable, protectable technology or a product. And the utility innovation is granted for an upgrade or improvement of such a patent. It's pretty long protection time. I mean, it's the term of the protection is up to 20 years. So if we summarize patent protection in China and in South Asian countries, you will have probably your first choice would be China to to consider patenting in Asia, and your first choice, if you're considering patenting, even if you're ready and you think that you would get the full patent, the invention patent registered in China, utility model can be your first choice, because it's simpler, it's cheaper, and it's faster, and it gives you a reasonable level of protection. As long as you're really sure that you're going to engage in a production, in manufacturing in one of those countries, or you are afraid of reverse engineering and circulating the product, which is just copy of your own, then probably you don't need to engage in patent protection anywhere in Southeast Asia. If you do, then probably invention patent is the best option for you, because there's not that much, there's no such discrepancy in how painful the procedure is between invention patents and the smaller patents, the design or utility model. And also, if you look at the numbers, predominantly in those countries, the invention patents are registered. Another side of the technology protection is trade secrets. This is something that I would like you. It's usually overlooked, or it's treated in a way a little bit too superficially. Probably you know what are trade secrets. Those are some. This is some information that has either technical or economic value for you, and that is deliberately kept secret from others. So the value of this information is based on your exclusive use. It can be something pretty obvious. It can be something which, I mean, it doesn't require really inventive or creative work. It can be a database with your customers in a country. It can be, the policy that you apply as to pricing. Those can be your conditions of your contract with your customers, right? These are also trade secrets, and they are protectable, and they can, disclosing that it can harm you economically. But what we're really interested here is the technology, is that anything from internal communication, from the outcome of tests in your laboratory, the blueprints, sketches, designs, descriptions, drafts of your patent application, manuals, technical specifications, even if you release it to your customers at some point, but you're careful enough to have your customers commit to a confidentiality obligation. These are trade secrets, technology-related trade secrets, which are protected. What does it mean that they are protected, that nobody else can benefit from them, nobody else can use them, nobody can take your maintenance manual and offer services offer servicing your products. Nobody can take a manual for training of your technicians and train their own technicians. Nobody can actually follow your formula for, I don't know, lubricants for a gearbox in a wind turbine, or a way of measuring performance or noise production of your engine, etc. So this is the whole sphere of, it can be data. I mean, which is not really, which is just collected, which is not really creative. A very, for example, in wind industry, a very valuable data is measurements of wind. I mean, on a site which is considered for a wind farm. You can have, and this is pretty unique. It requires a lot of effort and it's costly, but it's not really creative. It's just registering, day after day, hour after hour for a year or two, what are the wind conditions, what is the speed, what is the air density, what is the direction, and then you can actually predict what will be the production on the site, what turbines you should use, how you should adjust the software for it. Go ahead.
We have around half an hour left, so maybe we could just let you know where we are.
Okay. Do you think we could stretch it for something like 45 minutes?
Well, it's up to the participants.
Okay. Yeah, I mean, I don't have that much left, so I would like to wrap up the trade secrets, and then I have a couple of case studies, and then it will be just open for the discussion. So I think, yeah, let's try it for half an hour, and then we'll see where we are. As I mentioned, this is pretty self-explanatory, I think. Very often, trade secrets are referring to a patentable technology, but it doesn't need to. I mean, to have it protected under the trade secrets regime, it doesn't have to. You don't. There's no threshold. I mean, to how inventive this particular thing is. What is very important is once disclosed, it's not yours. I mean, once disclosed, you cannot claim protection unless it was disclosed by a third party, which sort of broke your reasonable protection. So if you keep your technology confined, if you require your employees to undertake confidentiality obligations, if you apply reasonable protection of your servers, computers, your offices, etc., you should be fine. How you can protect it? I mean, at some point you need to disclose it. You need to disclose some part of it to your customer or to your subcontractor, your manufacturer, etc. What you're really concerned is that someone who learns particulars about your technology will use this knowledge to either copy it or develop something based on your technology. So when you're disclosing it, you should make sure that there's contractual, working contractual system to protect to prohibit, to enforce the other party respecting your IPR. What usually most of the countries offer you to some extent protection under the law. In China, you have Unfair Competition Prevention Act, and what is important, it doesn't cover employees, it covers only competitors. So in China, you need to rely on contractual provisions, and what you think about contractual provisions, usually you think about non-disclosure agreement. They are usually not enough. They do not extend the protection to what is really important there, because your biggest worry is not that your employee or your business partner will disclose. They will just talk about your secrets. You're afraid that they will use your secrets to compete with you. So when negotiating non-disclosure agreements, you should actually focus on how the other party can use the information that you provide them. Not only that they need to keep it confidential. You have in China threefold way of protecting your, enforcing your trade secrets, but it applies to all intellectual rights, intellectual property rights. I hope there will be more detailed slide about enforcement, but usually there is a criminal activity because you have some surveillance, some espionage, and so there's a crime, and you can go this way. There is you can always go for damages. It's more effective. I mean, it's effective only when you can show your losses. If you don't have losses, if it's more your future place on the market, then it might not be that effective. And you have administrative enforcement. So the administration it's basically Ministry of Commerce. They can pass an administrative decision prohibiting a business entity from doing something, and there is a penalty if they don't comply. There is no law, no unfair competition law in Malaysia, only common law principles based on English law. There is some legislation in place in both Thailand and Indonesia, and in Vietnam. In Vietnam, it's based on civil law and contract and good faith. Contractual safeguards. I think this is an issue I would like you to remember and focus on. If you are, usually when you're starting a relation with some business partner, you might want to have an NDA in place, confidentiality agreement. And it would be really, really great if this confidentiality agreement doesn't really focus on non-disclosure, but also on how they use, what they can do with the information, so they cannot use it for circumventing your IPR. They cannot use the information that they got from you for their research, for their independent activity, and they are prohibited from competing with you on this field. What is particularly important is here: no creation and development of their own products, and no registration of their own IPR. So that then you would, if they do that, then you would have claim against them showing that they were actually not supposed to use the information they sourced from you to develop their own technology and to get the protection for it. It's also important to have in mind third parties. So the entity to which you disclose your confidential information should be obliged to protect it vis-a-vis third parties. So if they're working with their bankers, with their lawyers, with their technical advisors, they should impose similar obligations on those third parties. So you don't end up in a situation where, deliberately or not, you have some other entity benefiting from your technology. This is a very famous case which is now pending before the Chinese Supreme Court, and it refers to basically an industrial espionage, a theft of technology. This is interesting if you put yourself in the situation and you try to think what could have been done better, what should have been done. Was there any chance that this wouldn't happen? So let me tell you what is the background. You have a company which is called American Semiconductors, and they are I think that they are listed on the Nasdaq in the US, but they are sort of like a new company working on a technology. They were in particularly focused on the energy industry and offering software for power plants. And they specialized for the last couple of years, 10 years maybe, in producing hardware and software solutions for wind farms, in particular wind turbines. And that was to optimize their performance. So to react in the right way to the wind and keeping the electrical power curve in the most optimum way. And they were doing so. I mean, they were working mainly with General Electric, who is a major producer of wind turbines in the US, and but they became really successful in terms of, I mean, financially, when around 2008, 2009, they started to cooperate with the major Chinese producer of wind turbines, and this is sort of like at the same time when the Chinese government started to invest and to underline the need for producing, environmentally friendly sources of energy, like renewable industry. So you have a moment which a few years ago where there started to be when massive projects started to be implemented in China in the renewable industry. And just to give you I don't know the numbers, but just it talks to my imagination. I read this line in some article in Poland that every year there is more power being connected to the electric grid in China than it exists in the whole Poland. So there's like the output that we have, every year, this production. This is how much the need for the electricity and the actual connection takes place every year in China. And part of that is the boom in the renewable industry. So basically they are generating, from this cooperation with Sinovel, they are providing them basically software or parts of software which is utilized for controlling the wind turbines and controlling the whole wind farms. And they do it in a pretty, I mean, the American Semiconductors, they were considering different options how to protect their position so their technology is not copied. And they do have patent protection for software, especially when the software is integrally combined with the hardware, which is applied in the machinery, in the wind turbines. But they couldn't go this way in China, and they were afraid that disclosure, even if they try to patent, the parts of hardware that they are using, that will expose them to a major risk of their technology being copied by third parties. So they focused basically, the only entity which had access to their technology was their partner, the producer of wind turbines. So they had only one entity to take care of. Nobody else really had access to that. Not the wind farm owners. They were the producer were also servicing and maintaining the wind farms. So you have just one entity. Like, going for patent protection is first a little bit, well, it's ineffective because you can't patent software in China, plus it wouldn't be really that smart because you would be disclosing to your technology to an unlimited audience as opposed to focusing on this particular entity. So they were relying on protection of trade secrets, and part of that was that they were controlling the production. So my understanding of the background is that the software that they were providing, or part of the software, it was just a black box, just a coded solution that wasn't in any way improved or integrated or messed around by the wind farm producers. Same thing with the hardware parts. They were producing them in the US, just bringing to China. And they had, adequate non-compete and confidential contracts with Sinovel. What happened? Some 2 years ago, they experienced a slowdown. The orders from Sinovel were drying out, so they were not getting any new business from there. And they first thought that maybe there is some decrease in the production of wind turbines, etc. And they started some investigation. They figured out that actually Sinovel is making the turbines, installing them. They have like a massive projects in the northern part of China, and somehow they have their software. They broke it. They are able to produce it themselves. And then the question is, how did it happen? It turned out that they just bribed employees. They bribed these American engineers who disclosed. And it was like a massive project because they were actually based in Austria and in the US. So it required some effort from Sinovel. So you have your partner who is spying on you, who is actually corrupting, offering bribes to your employees to get your product, and they are copying this product and implementing that and benefiting from that. It was difficult to actually go after Sinovel in China. The American semiconductors, they lost in 2 instances in the court. They were successful in bringing criminal charges to their employees, but not to Sinovel managers, or not to Sinovel employees. And now the case is pending before the Supreme Court, and there is tremendous political pressure from the U.S. And I think only because of that the Supreme Court decided to hear the case. We should have pretty soon, because we should have the judgment, the outcome pretty soon. What is the problem here under Chinese law? Whether you need to prove, and this is the case for the American semiconductor, not only the result, but you need to prove actually a malicious, willful action by Sinovel, approved by their managers, to actually go after them for damages. So it's not enough that you prove that they are using your technology, even though they were obliged not to use not to try to circumvent and use your technology independently, because their line of defense is that they got it from a third party. They got it from independent third party, and they structured this whole espionage thing in such a way that they actually bought this license from another entity, which corrupted the employees. And they are saying that it wasn't a protected trade secret anymore because it was available from a third party, and they are not responsible for how the third party got in possession of this information, of this technology. And this is it will be a major breakthrough if this case is decided for American Semiconductors, because it will really increase the in practice the level of IP protection in such a context. I think that they couldn't do anything else. I mean, they couldn't really secure their rights in any better way. I mean, if you look at their situation, there were no other enforceable measures to look for, and their competitors could. I understand that it wasn't. They were not able to reverse engineer, so they needed really some inside knowledge. So they needed to corrupt the employees. So in this way, what American Semiconductors did was right. I mean, they shaped the production process and the deliverables to their partner in such a way that it wasn't, easy to just dismantle it and see how it works. But you can't really protect yourself from, you need to have employees, you need to have engineers working with you. You can't keep everyone in the darkness. So in this sense, I don't know if there was anything from the legal or like IPR-oriented thing they could have done better. If you look at the broader picture, I think that what they should have done is to enter into a joint venture with Sinovel, and then try to, actually bring the IPR into this joint venture and disclose it to Sinovel, and have a very close relation with them, become partners with them, and actually it would be much easier to protect the rights of this joint venture, where the information, when the technology was fully disclosed to the other partner, where the other partner couldn't be really claiming that they got it from a third party, that they have now a different supplier of this solution, if the technology was already known to them, was already disclosed to them. Plus, with the framework of a joint venture company, they would be able to actually block, based on the principle of prohibition of competition between the partners of a joint venture. They would be able to prohibit Sinovel from acquiring the same technology from a third party, right? So they would be able to force them to actually utilize only what is coming from the joint venture company. It doesn't mean that it would succeed, but I think they would have a better chances, which leads us to another thought or a conclusion, that sometimes when you're approaching a new jurisdiction, a difficult jurisdiction like China, and you're trying to do it step by step, it doesn't have to be best solution. Sometimes, like, really jumping in and thinking forward is more beneficial, because this model is very popular. You start with cooperating with a business partner, you deliver your product or your solution, and you will see what happens. You will see how this turns out. And usually that's a good approach. In this case, it's proven to be a mistake. Yeah, so that's the other part. We already talked about this case. There is, how much time do I have now, or 5 minutes?
10, 15 minutes.
10, 15 minutes, wonderful. So I would like to, it's sort of like reverse of American conductors, semiconductors and Sinovel. It was a case I was, because about this case I just read, and I think it's very powerful in showing you how fragile you can be in China. The one that I would like to tell you about is a case I mean a problem I worked on. It was a European, basically Polish producer of pharmaceuticals. They were entering China, and they were kind of entering China, but it was difficult. So they had a really nice product. There was a demand for this product on the Chinese market, and pharmaceutical market is heavily regulated in China. And I think at that time when they initially thought about entering the market, they needed to have a Chinese partner in a joint venture to apply for the permits to the Pharmaceutical Supervision Authority for having their drugs to be admitted on the market. So they formed a joint venture company, and this joint venture company ends up to be the owner of the owner of the trademark, and the owner of the right to bring, package, and distribute the drug on the Chinese market. Of course, it went wrong. So the joint venture, their partner in the joint venture was a Chinese small company, small pharmaceutical company, which was established by some professors. I mean, some people with academic background and good relations with the authorities, and there were proper introductions. They met through some university exchange program, etc. So there were like high-level recommendations on both sides, and everything looked nice. The joint venture unfortunately wasn't successful. I mean, the partner didn't really know so much about the market. There was, lack of, they didn't have, both of them, they didn't have sufficient funding for building a network of distribution. And the Polish company decided to change a channel for the distribution. They wanted to go with a major multinational pharmaceutical company and actually offer this multinational a right to distribute their product in China. And actually it looked really, really promising. They were estimating that there is a population of something like 100, 120 million potential customers. And the other, I mean, the competing products, the drugs, I mean, the same drug was either good quality and very expensive or pretty bad quality. So there was like a nice market niche. It was quite big and everything looked promising. There was one obstacle though. You couldn't, I mean, initially they thought that they can just cancel the decision of the Pharmaceutical Supervision Authority for the license for the distribution, and they can reapply on their own behalf or with their new partner. It turned out that they couldn't. They couldn't have, and they couldn't have another license for exactly the same product. They had a problem with packaging because the trademark was also registered for the joint venture, and now comes the question how to, wiggle out from this situation. And the Chinese partner is, they are quite okay with their partner, changing their plans, but they want actually to benefit from that. They didn't really prove to be helpful or successful in any way. So this is just, squeezing the opportunity. And this is something that you should really take into consideration when choosing a partner, when dealing with, and when entering some contractual obligations. You can't that easily withdraw from a company in China. You can't, liquidate the company without the consent of your partner. As long as you are a shareholder, a partner in a joint venture company, you cannot compete with it. So you cannot allow another entity being formed in China which would import the same product to enter the market. You just need to go through the same channel. Otherwise, you're liable under the the regulations on the joint ventures and the competition law. So it ended up that they needed to pay premium for acquiring the shares in this joint venture company to basically to pay off the former Chinese partner. That was quite sore. That it took a few months to negotiate the transaction and actually, to withhold the whole project, the entering the market. Then there were complications with the pharmaceutical supervising authority, with issuing permits for packaging. There was something wrong with the initial registration, though. So we needed another application. So the whole process, it took something like up to 9 months from the initial stage. From the initial stage, which was actually having a distribution contract negotiated and signed with the new partner. So the same thing that proven to be a mistake here, in another context, it's even it's also a mistake, right? So I don't know if it tells us anything except that China is a difficult market, and yet that you need to, but you shouldn't be scared away. There is more and more going on, and they are pretty used to dealing with foreigners by that time. It's like it was different 10-15 years ago, but now they understand us better. They understand why we insist on signing contracts and having everything in order, and not only relying on the relationship. What you should do, you should take the easy steps. So you should prevent the infringements that you can prevent easily. So trademarks, work with customs administration, work with authorities. Try to push as much as possible on the authorities. Don't rely only on the courts, because you are disadvantaged in a court. In terms of that, you need to have a local attorney, you need to have a lot of documents translated, etc. Always, look closely and just take your time when entering the market and choosing your partner. Don't go with the first guy that you meet at some trade fairs, and work on the contracts. Don't sign crap. Just be very particular in whether the contract is going to work. Go ahead with analyzing your risks and your expected benefits before you go into any litigation. Litigation can be very long, very costly, and courts in China are getting better and better, but still you will always have a disadvantage as a foreign entity in terms of understanding the procedure and just communicating, etc. But never ever rely on a judicial protection of your home country. So the choice is arbitration or court in China. Basically, I mean, with some exceptions, Chinese courts do not recognize judgments from different countries. So it's a waste of time and money to put into a contract, for example, that the dispute resolution venue will be a court in Zagreb. They are not going to recognize that. You will spend a year here, then you will bring your judgment to China, and you will apply to the court for recognition and enforcement, and you will spend another 2 years fighting that, and then you will need to litigate again. So don't do this. Don't make this mistake. Arbitration makes sense, though. Arbitration is really nice in commercial context. With IPR, not necessarily. With IPR, sometimes you need because arbitration is really good if what you seek are damages. If you suffered losses and you want to get damages. But if you want an injunction, an order to compel to stop something, then you need the court. Actually, you need the arbitration courts will have very, very limited power to issue an injunction. And then if it's a foreign arbitration court, then not necessarily such an injunction will be recognized in China. So in IPR context, if you're transferring technology, you're licensing something, you have a distribution agreement, do go with Chinese court. I mean, choose Chinese court as a dispute resolution venue, but still, before actually getting into fight, try to figure out what other options do you have. Chinese and basically Asians are not very litigious, I mean, as a society. So they consider us a little bit aggressive in terms of how we negotiate. I mean, us, people from Europe, how we negotiate and how we behave when there's a conflict. So, and I've seen that, and I even heard stories from their side, how surprised they were going into the court where their opponents was not friendly, was like really telling some awful things about them, and they were like shocked. How can we had dinners before, and now we have some dispute, but there's no need to be so rude and to be so also consider that like there is a huge cultural difference. What I'm trying to say is that always try to talk and mediation, and try to find a third party which can like moderate the mediation. It can be more effective. It's always more effective to have your opponent to convince them to do something than to force them. But especially in Chinese context, it might be more time efficient and it might be less costly. Use different ways to protect the same assets. So contract, trademark, registration of your trademark with customs services, so they actually monitor for you what is going outside China. Confidential information, trade secrets, very, very important. And something that is not really legal, it's more like project management. Try not to disclose everything if you don't have to. Try to keep like checks and balances, like don't have your partner's staff coming to your manufacturing facility in Croatia and like looking into everything. Keep them at their arm's length. Try to figure out a way of controlling the production process in such a way that you still have some secrets. There is still you still need it. Yeah, that's it. What we do, there's a lot of materials on our website, so I would encourage you to take a look there. We offer webcasts and trainings, and some are live trainings like this ones, but you have a variety of topics and industry-focused materials available through the webcast or some guides and newsletters, etc. We offer one-to-one consultations, and what we do is just we don't take your case and we don't help you all the way along. We just provide you with some initial consultation, like what to do and where to turn. So this is just the most effective thing to help you at the very beginning of the process. Lots of publications. We have workshops and trainings in different languages. And we have basically two websites, two portals. One is devoted to Southeast Asia, and it's pretty new, but it's really, really informative and actually, because China is easier topic in the sense that EU and European companies were interested in China for a fairly long time, and there's a lot of materials, books, etc. available on China. Not that much on Southeast Asian countries, so I would encourage you to check out both websites. Questions, comments. I'm happy to stay and talk. I understand that we should be heading for the lunch. Yeah.
We can have a Q&A.
Yeah. So you can have a Q&A now or after lunch. Now.
I would suggest maybe to have it now.
Perfect.
While we're still fresh.
Excellent.
So.
Yeah, go ahead. Any questions?
Maybe how do you protect your information with your partners?
Could you say it again for the
The
sake?
last thing you were mentioning, how do you protect your business knowledge from your employees, with your partners?
In contractual sense, like what you need to do to have an enforceable contract. So those are two. I would say two different spheres. The one are business entities, and the other one is employees. And with the employees, it's somewhat tricky because the labor law and the Unfair Competition Act does not really provide for obligation of an employee to, confidential obligation and obligation to not to compete with the, after the employment relation ceases, not to compete with the former employer. With the potential competitors, business entities, it's easier because the Unfair Competition Act applies. So what you need to do in both cases is you need to address it in the labor contract. The question of the non-compete, so the confidentiality, and you need to cover also the prohibition of using the knowledge, like the residual knowledge that you for any competitive activity. You need to put a timeline on that, so you cannot prohibit that forever. You cannot just ask your employee to forget everything that they learned. You can oblige them to not being employed for some time in the same industry, or not being employed, or not seeking employment with a direct competitor, or not undertaking a competitive business for some time. And it needs to be clear that there is some consideration for that. So they're actually getting paid for that. So this is included in their salary, right? So it's not something that they are just promising, but then they can claim, but we didn't get anything for that. So basically contract. You don't have any, unless there was some criminal activity. So your employees were spying on you. So they were accessing the materials they were prohibited from accessing. Then you might have like industrial espionage charges, criminal, but usually that's not the case. Usually the problem is that you train your employees and they learned how you conduct the business. They have their own relations with your customers, and then they just take it away. But I think it's like everywhere else in the world. You just you have this risk when you're running a business. loyalty. I don't really know how to, because if you just keep everything secret, and then it's really harming your internal like corporate culture. So if people don't trust each other and they're afraid to talk about things, then it's like strange. On the other hand, if you're like too loose about it and you don't make it clear that this is something which is internal for internal use and you don't bring it outside, then it's also not that good. But probably it's just too long answer for a simple question. You need to have it in the contract. Yeah.